campus of North Idaho College and today's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist Tony Stewart.
Today we wish to bring you the fifth program in our 6-week series on Know the Law. Our topic today is wills and estates. Before introducing the program, though, it is very important for me to announce to you that we will not be on next week, and in the week following that, on February the 20th, we'll bring you the last of this series entitled The Rights of Criminal Defendants. I would also like to remind you that we'll be changing our air time, and we'll be moving to 11 a.m. on Sunday morning, starting with that show on February the 20th. In order to discuss the important topic of wills and estates, I'm very happy to welcome to our program from the Kootenai County Bar Association 3 guests. First of all is Coeur d'Alene attorney Steve AYERS, also an attorney in Coeur d'Alene, Mr. Paul McCabe, and from the judicial system, Magistrate Al Parasol. Gentlemen, welcome to the program.
Thank you. Thank you.
I'm very happy, as we've had in the past 4 weeks, to have Lou Reed back to join with me in questioning our guest, and I will invite her to commence the questioning.
Thank you, Tony. Gentlemen, let me start out with the simple question of why do I need to have a will? Can I start with you, Paul? Why do I need a will?
You may or may not, in the absolute technical sense, need a will, but I feel that in most cases a will is advisable. A will is designed primarily to set forth the disposition of your estate on your death. And in that will, you determine how that estate is going to be distributed among your various heirs, beneficiaries, charities, whatever your desires may be. A will, however, can accomplish and can do for you a great many other things. You will want to appoint your personal representative. You will want to select someone with whom you have confidence and whom you know will administer your estate the way that you have directed. You can do certain things such as appointing guardians for minor children in the event that you should die prior to their reaching the age of majority. You can do certain things in the way of tax planning with trusts to try to minimize tax impact. You can use trusts to take care of family members that may not be, or that you may not feel are capable of administering the assets that will be distributed to them. And finally, I think with a will, it provides a tool that can make things easier for your heirs in handling your estate. I think that with a will, that your estate can be handled in certain cases, if the circumstances lend themselves to that, to an informal type of a proceeding. And I think that with a will, in a good many cases, you can expedite, streamline the proceedings, and reduce costs.
I think that's very helpful, and that's kind of an outline that perhaps we can use further on in the program. But Steve, let me ask you, when you think, with all those items in mind, when you think a will really is unnecessary? Is there a person who perhaps will not have sufficient assets, or it will not justify their taking the time to draw one up?
I think if the person knows what will happen to his estate if he does not have a will, as far as where will the assets go, and that if he's happy with that, what the law provides, if he does not have a will, then I suppose he does not need a will for distributing his assets. He may, for one of the other purposes that Paul mentioned, if he has minor children, appointing a guardian, setting up a trust for the minor children, and things of that nature.
Judge, would you comment on what you called an old English toast that lawyers sometimes call forth, drinking to, saying, here's to a man who draws his own will. Oh. What's in it for lawyers?
Well, are you talking about the will?
Well, the old aspect of here's to a man who draws his own will.
That's just a comment that
complications.
come out of an old professor that I studied under in law school who had also studied at the Inns of Court in London, Brocklebank. And one of his comments was that every year at the Inns of Court in London they drink a toast to the people who draw their own wills. And the indication there is that by attempting to do what they should have done through competent counsel, they create problems for themselves that it provides the lawyers with a good living just working out the mistakes they made.
So it underscores the fact that drawing up a will may avoid a lot of complications.
That's correct, and it's
future.
desirable, and if you're going to do it, you should have it done by someone who's knowledgeable and learned in the field, and they can consider the various aspects that should be dealt with.
Thank you. Back to you, Tony.
Judge Parasol, I would like to pursue what Lewis just mentioned to you. Since in the courts that you must deal with this when cases are brought before you with the states, I know that a lot of times there are conflicts between those people who might be eligible to receive a portion of the estate when there is a death by the owner. As you get involved in the necessity of probating and looking at the issues, and you may have to be involved in a lot of decisions with attorneys on both sides, what are some of the problems that you face if, one, there is no will, or secondly, there is a will that's poorly written by the deceased themselves, they're not trained in the law? If we had this more clearly defined for our viewers of what would prevent trouble for their heirs and you in the court, what kind of recommendations would you make?
Well, my first recommendation, again, is to have your will drafted by someone who's knowledgeable. The danger in attempting to do it yourself is that you may omit people who should be named in the will. You may do that inadvertently. That may invalidate portions of the will. If you attempt to do it without giving consideration to some of the statutory requirements for execution of a will to establish that it's valid, or if you attempt to handwrite a will, an olographic will, you can get into some problems unless you conform with what the law requires for olographic will. And usually people try to, when they're writing their own wills, they try to short-circuit the matter, and they would really be better off if they didn't write a will at all in many circumstances, because they're introducing complexities that wouldn't be there if they just died intestate and their estate passed by the laws of intestate succession.
Mm-hmm. So I'm reading from what you're saying that it might be better not to have one at all than to have one poorly written, or
sometimes you're better off if you don't have one at all, rather than have one that is poorly written and one that may cause problems that you certainly didn't intend to create.
I would like to ask our two attorneys, too. They may in their practice already run into this problem. Oftentimes there is conflict among family members, or sometimes there are two families involved. Let's take a person that has quite a bit of property, and that a gentleman marries when he's fairly young, and he raises a family by his spouse, and then there's a separation or divorce, and there's a second marriage, and oftentimes there's a will that's quite old, and then there's a will that's very new, just before his death, 6 months or 3 months, and he's been ill during that time. And I've seen cases where there is a very serious conflict and a contest in the courts between whether he was sane and rational at the time he wrote the second will. I'll start with you, Paul McCabe. Is this a problem, and attorneys are involved on both sides? What should individuals do to make sure that the will that they want on record is the one that will be there for the court, and how can they prove that they were not over pressure, that they were very sane at the time that they wrote a will?
Well, I think you raised what to me is a very important point, Tony, and that is that once an individual executes a will, he shouldn't just let it rest at that point. Family situations change, the nature of an estate can change, and so consequently you should be constantly reviewing your will to see whether it needs to be updated to take care of these changes. You mentioned the situation of a second marriage, and you've got two families, the wife's children and the husband's children, both by former marriages. I think in those kinds of situations it's very critical that an individual have a will, because without a will, of course, the assets are going to be distributed in accordance with the laws of intestate distribution. And if you have certain separate property as opposed to community property, you might get a result that is something other than what you had intended. As far as the person's competency in drafting a will or in executing a will, the presumption, of course, is that a person is competent. It becomes incumbent upon the person that's challenging that will to prove through whatever sources that he might have at his disposal, generally through medical testimony, that type of thing, as to whether or not he was in fact competent at the time that he executed the will. But I think the important thing is that the will must be continually reviewed to see that it takes care of changing family situations and estate situations.
Steve Ayers, I will ask you this follow-up question that Paul brought to my mind with his answer. Let's suppose that an individual dies that's fairly wealthy, he has no will at all, but he's had two families. We've already had on this program the difference between community property and separate property. And let us suppose that most of the property is community property. Will his second wife and children, if there's children from the second marriage, will they get most all that property? What's the status of the children from the first marriage and the spouse? I know that there's intricacies into this in a given case, but in a general way, can you give some advice to the viewers what might happen?
Yes, in that situation, making the assumption that most of the property in the estate is community property, it would in fact pass to the second wife. As to his separate property, the non-community property, the second wife, or what's referred to as a surviving spouse in the code, would get the first, or correction, if he had children by a prior marriage, and I don't know if he had any children by the second
Let's
marriage.
suppose he had children in both marriages. Yeah.
Well, the code provides, I believe, and the other gentleman can correct me if I'm wrong, that as to the first $50,000 of separate property would go to his surviving spouse, and she would also get 1/2 of the remainder over the $50,000.
And would the other 50, would the remainder of that half then go to all the children?
Right.
Fine. Lou Reed.
Well, this is just another wrinkle of the same question, but I think this is the sort of question that comes up. Frequently, before people die, they may drop a will that shows that they're really very cross with members of their family or that they have other choices. And so if a person in a will decides to leave a vast amount of money to a cat or to an orphanage or a foundation, is there precedence for the family to challenge that, not on the grounds of senility or incompetence, but just on the grounds of frivolity or other kinds of obligations? Let me direct it to you, Paul,
well,
if I may, again.
In those certain circumstances, I think that, number one, you're providing ammunition to somebody that wishes to contest the will that, in fact, apparently he might not have been possessed of his faculties if he wills it to a cat or a pet or something of that nature.
We would all question this.
Yeah, and so, you know, that provides some ammunition for somebody to start with. There are certain limitations on devises to charity, to charitable institutions. If the individual dies within a certain period of time after executing the will, those, as I recall, and you can correct me, Al, those are voidable. And I believe it's 90 days without checking the code. I can't remember. But at any rate, yes, those types of things can be challenged. Unfortunately, you know, there may be certain circumstances where it cannot be, but they certainly give rise to somebody challenging it.
The issue, I think, to some degree, is how much control a person wants or can have beyond death. And I'm certain that there are instances where there is an overreaching attempt made by the person to actually have that kind of control. Are there lots of instances where wills are altered after death? I'm thinking of Cecil Rhodes' will, which is one I'm aware of, where his will was altered to permit women to be eligible for Rhodes scholarships. Is there much precedence for this, where the court actually is saying you really have to stop here, and events that take place and subsequently will perhaps take precedence? Judge, is that a good question?
I think that it would have probably limited application. There may be circumstances where money is left for a specific purpose, and a court might determine at a later point that that was no longer a viable purpose and might expand it. Your example of broadening bequests to an institution for women might be construed in some given instance to extend to women and men both, or if it, but generally speaking, you've got a right to fairly well control those things in your will.
Would you like to comment on that, Steve? I didn't give you a chance to comment earlier.
Well, if there is a fraud or a forgery, it's up to someone to bring it to the court's attention, of course. And so you have to have basically a contest of the will. And what sorts of proof are available is going to depend on the circumstances of that particular case. And the court can only deal with what's presented to it. And as a practical matter, there may be more alteration of will than anyone is ever aware of, and I suspect that there is.
But basically, if a person can draw, if he draws up a good will, can have some faith that this is going to be carried out as is written, and can, in that way, exercise quite a bit of control?
Even if you leave it to the cat, usually, yeah.
Okay, thanks.
One thing I might just add there, Lou, and that is with respect to altering of wills, an individual can during their lifetime change their will, either by executing a new will or by executing a codicil, which is an addition to a will. And we've been talking about executing wills and having it done by somebody that's legally trained. It's just as important that the alterations or the codicils to a will be done by somebody that's legally changed. Sometimes an individual will attempt to modify their will by making cross-outs and thinking that if they initial that constitutes an effective change. It may not only be ineffective, but it might invalidate the entire will. So any alterations to the will should also be done by somebody that's legally trained.
Well, a further point on the same is the ability to incorporate by reference distributions of property. For example, an individual might desire to get rid of certain personalty, and they'd make a list, but in the will they provide that may be changed from time to time without changing the whole will. They can just go through and modify their disposition of personalty.
What you're saying, though, is that a will should be regarded as an organic thing that you review from time to time. It's
Correct.
not. Fine, thank you.
Paul, when you were surveying the whole idea of accomplishing, what a will accomplishes early in the program, you may have mentioned something I've heard before, and I think it might be very important to some of our viewers, and that is the tax implications of an estate with or without a will. Could you go through some of the main reasons why it would be an advantage to have a will over not having one for tax purposes? And I assume you're talking about either federal or national tax and state tax both.
Speaking primarily to the federal estate taxes, and I don't pretend to be an expert in taxes. What I was speaking about was in a will you can provide that, particularly in a husband and wife situation where you're dealing with community property. You can provide that in your will, let's say that the husband passes away first, that his portion of the estate, his one half of the community property, be held in trust. And during the wife's, the surviving spouse's lifetime, she would have the access to the income and the principal if needed, with the provision in the will then that upon the surviving spouse's death, that the trust assets are transferred or distributed to those individuals named in the will. Now what that does is that prevents the husband's half of the estate from going through the wife's half on her death, and therefore, let's say if you've got a $400,000 estate, two $200,000 estates. On the wife's death, then you don't swell that estate and have another $400,000 estate to be taxed, but rather a $200,000 estate, and the husband's half passes through the trust and not through the wife.
So you're cutting in half the amount that you're responsible for in the tax system.
That's correct.
At
yes.
one stage, yes. Steve, I'd like to get into a little bit of a different area. It's something we've been talking on, and there's just so many ways of looking at these things and trying to clear them up. I want to go back to something that's contested quite often in wills, and that's the question of mental competency. With any experience you've had, and then Judge Parasol, you have to deal with in the court so often. I'd like both of you to actually deal with this. If a will describing the estate is in court and has been contested on that one ground, the lack of mental competency at the time that the deceased wrote it. What are the kind of things that we're looking at that might cause the will to be thrown out? What kind of proof do you need to prove that the person was not mentally competent when they wrote the second will?
Well, outside of looking at the provisions of the will itself and how reasonable they are, also extrinsic evidence or witnesses can appear and testify as to the state of mind of the person and how they were conducting their life, whether they knew the extent of their assets and how the decedent was managing their assets at the time that they wrote the will or had the will written for them. All these sorts of things would be relevant in order for the court to make a decision, was that person competent to write the will or not.
Judge Parasol, do you find some particular examples of problems that you face in trying to make a decision?
Not really. It's pretty much as Steve says. One of the things, and I think Paul indicated this earlier, that might trigger some inquiry is whether you, in a will, don't provide for the natural objects of your bounty. If you leave the kids out, or you write the kids out, if you write the wife out, if you write the brothers and sisters out, and you leave it to some stranger that you've known for 6 months, that may raise a question. That's a factor to be considered. But basically, you're relying on extrinsic evidence, testimony from individuals who have known this person for a period of time and can testify, yes, he was behaving oddly, or no, he was not, and it's indicia of that nature that would really pretty well point the answer.
When you have a rather large estate involved and you bring in the question, that or other questions to the court, again for our viewers, are those kind of decisions decided by a judge presiding, or is oftentimes it a jury decision?
Basically, judge.
Lou Reed.
Judge, what advice do you have to the parents of young children when they're thinking about drawing up a will and they're going to have to enumerate who should be the guardians? You know, obviously we would all like to will our children to the Rockefellers or something like that, but what is the kind of advice that parents need to feel assured that they're making the best judgment?
And this goes along with one of the reasons for having a will. Even if you don't have a significant estate, you can make provision in your will for a guardian. In most families, if you have a number of individuals, brothers or sisters on both sides, most families you have one or more that you really wouldn't be too crazy about raising the children because you haven't been convinced that they did a good job with their own, you know, or
they may even be your parents.
Sure.
Yes.
But you can select the best alternative as you see it for a guardian for that child, who has perhaps the best temperament to deal with children, who is of an age where they could appropriately raise children of your children's ages if something happened to you and your wife. It provides that vehicle, and I think that's a very essential factor to be considered in deciding whether you need a will or not, even, as I say, if you don't have a very large estate.
The simple question, but do you think it's wise for the couple to consult with the chosen guardians before they include them?
Oh, I think that's absolutely necessary. You don't want to name someone in there that might decline to act, for example, and particularly this is true if you're going outside the family. Usually within the family they'll agree to anything for a time. But if you're going outside the family, then it's really essential to discuss that with them and see whether they would be agreeable to rearing those children. That's a great responsibility.
Thank you. Any words of advice from Paul or Steve?
Well, there are a couple other practical matters that I've encountered, and that is, for instance, what kind of a relationship are you going to create when these new children come into the existing family? If the family is a two-children family with let's say a 2 or 3 bedroom home, and you've got 6 children, what kind of a hardship is that going to impose on this new family? If the family that you're saying is going to become the guardian are of limited means, and the children that are going to be coming in to the new family through the will are going to be receiving substantial funds. What kind of jealousies and what kind of frictions is that going to create? So I would consider those types of things too.
The impact.
Yes.
Steve, any additions?
Well, perhaps on a little bit related subject, in addition to naming a guardian, you can also name a trustee, and it doesn't necessarily have to be the same person. You may have a great deal of faith and trust in a person to raise your child, but they just might be a really poor manager of money, and you wouldn't want them to be spending the funds to buy him a hot rod or whatever as he grew up. You might want to name another person or even a financial institution such as a bank as trustee to overlook those funds and to invest them and to ultimately distribute them to the beneficiary.
So those are thoughtful options.
And I think that's an excellent suggestion of Steve's, and just to expand on that a little bit, in a lot of cases probably for the administration of the funds, a trust is better than a guardianship, because under a guardianship at age 18, that child is going to be entitled to receive whatever proportionate share he's entitled to. Under a trust, you can provide that child will not receive the funds until a given age, and I usually suggest to my clients 25. In the meantime, they still are able to receive funds and parts of the principal if they're needed.
We're just about out of time, but Paul, I'll direct this back to you for a moment. I'm aware that the viewers think different things as they're watching the program, and I just suspect there might be someone out there that is trying to visually see what a will's like. And could you take just a moment in discussing planning a will? What kind of documents it look like? Is there specific forms, or is it in a narrative? What should it include, and should there be witnesses to it? What's the format of a will?
Well, a will just primarily sets forth what your family situation is, your name, your spouse's name, who your children are, whether or not any of those children have predeceased you, and whether they have left children. Obviously, you want a clause in which the proceeds are distributed in the manner that you've selected. You want a clause in which the personal representative is named, and I think it's also a good idea to have an alternate personal representative named in the event that the primary one cannot serve. Then you can get into your other things like your guardianships and things of that nature. It must be witnessed by at least 2 people.
And have the whole thing notarized?
It does not necessarily need to be notarized, but if it is notarized, it's what's called a self-proved will. You can go to court and prove it without the necessity of bringing in the witnesses unless there's a contest.
Okay, I'm sorry we're out of time, but thank all 3 of you. It's been a very informative program for us, and we appreciate your time and your very fine, informative information. And I express my appreciation to Lou. Ladies and gentlemen, I hope you'll be with us week after next on the 6th and final program of this series on the rights of criminal defendants. Please have a good week. I am Tony Stewart.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time.